Almighty God, who in thy wisdom and goodness has appointed the offices of rulers and parliament for the welfare of society and just government of men, we beseech thee to behold with thy abundant favor us thy servant whom thou hast been pleased to call for the performance of important tasks in this land. Let thy blessing descend upon us here in this house assembled. Grant us that we may treat and consider all matters that shall come under our deliberation in so just and faithful a manner, to promote thy honor and glory, to advance the peace, prosperity, and welfare of this country, and of those whose interests thou hast committed to our church. Amen.
Correction and approval of records of votes and proceedings of the National Assembly sitting of Monday, 9 September 2024.
Honorable members, the record of votes and proceedings of the National Assembly sitting of Monday, 9 September 2024 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Any honorable member? The member for Sabah Sanjang.
Thank you very much, Honorable Speaker. I rise to move that the record of votes and proceedings of the National Assembly sitting of Monday, 9 September be corrected and approved.
Any seconder? Member for Eliasa.
Thank you, Honorable Speaker. I rise to second the motion.
It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Monday, 9 September 2024 be approved. Any correction or observation from honorable members may do so by show of tap. We will be looking at the record page by page. And if any member have any issue or issues, may do so. Beginning with page 1. Page 2. Can we move to page 2? Page 3. Member for Sabah Sanjang on page 3.
Yeah, on page 3, under consideration stage committee of the whole assembly. Immediately after that line, at 47 minutes after 10 o'clock in the afternoon, that should be changed to morning. Thank you.
The last item on page 3, at 47 minutes after 10 o'clock in the afternoon, he is proposing for the afternoon to be changed for morning. Member for Latikunda Sabiji.
Thank you very much, Honorable Speaker.
Point of order.
Thank you very much, Honorable Speaker. The following honorable members were absent with permission. Honorable C.D. S.K. Njai, Deputy Speaker. We want to know how this permission was sought, because what you know, you travel, you are not in the country, so I don't know how this permission was sought. Can you please explain?
Member for Brigamanot.
To do with the minutes.
Anything on page 3? Page 4? On page 4? Can we move to page 5? Page 6. Honorable members, it has been moved and seconded that the record of votes and proceeding of the National Assembly sitting of Monday, 9 September 2024 be approved with amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clap.
Order 51, matters of the day. Matter of the day addressing the threat of hate speech and harassment in our society. By Honorable Jibin Mbala, member for Lower Flood West.
Honorable members, my office is in receipt of a request made by the Honorable Member for Lower Fuladu West seeking permission under Clause 51, 1 and 2 of the standing orders to make a statement to the Assembly on the threat of hate speech and harassment in our society. Honorable members, having considered the request of the Honorable Member under the provision of standing orders clauses 51.3 A, B, C, and D, and 51.5, and noting that the request has satisfied the standing orders provision, I now grant the Honorable Member leave to make his statement to the Assembly. However, I wish to draw the attention of Honorable Members to clauses of 51.8 of the standing orders that the time allocated for the matters of the day shall not exceed 3 minutes for the Honorable Members who may wish to make statements, and the time allowed for the matter of the day is 30 minutes. Therefore, I also urge Honorable Members to observe Clause 51.9 of the standing orders for guidance. I now call on the Honorable Member to make his statement to the Assembly. Honorable.
Thank you very much, Speaker, for giving me the floor, but I rise to withdraw.
Let me say,
Order. Honorable members. Order, please. Order. Order, please. Honorable Member for Latikunda, you may have the floor.
yeah, thank you very much, Honorable Jibimbalo, for bringing this important.
Point of order. Point of order. Point of order.
He delegated me to read it. Yes.
Member for Fonyi Councillor.
Yes, Honorable Speaker, I want to appeal the Honorable Member for Lower Fuladu can hand over to me so that I could take the lead, if possible. Yes, this is an important thing.
Honorable Member, you know you are out of order. Honorable members, the matter of the day, of course, which was requested by the member for Lower Fuladu West, has been withdrawn. Clerk, can we proceed?
Bills. Order 72, continuation of the consideration state on the Criminal Procedure Bill 2020 by the Honorable Attorney General and Minister for Justice.
Honorable members, please order, honorable members. Order. Order from the majority bench, please. Order. Honorable members will recall that after the second reading stage, the bill automatically stood referred to the ABC. Therefore, the ABC scheduled the bill for the consideration stage during the previous ordinary session in March, precisely on Monday, 22nd July 2024. However, the Assembly could not complete the consideration stage of the Criminal Procedure Bill and stopped at clause 78 of the bill. During the said sittings, and suspended the process to be later date. Therefore, the bill is appointed today for a continuation on the consideration stage in accordance with Order 72. During the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the Assembly into Committee of the Whole Assembly to give consideration to the bill, that is the Criminal Procedure Bill 2020.
Okay.
Honorable members, the Assembly will now go into the Committee of the Whole Assembly to consider the Criminal Procedure Bill 2020, clause by clause. We will be guided by Order 72 of the standing orders during the consideration stage. Clerk.
Clause 79, methods of instituting criminal proceedings. Yes. We stop at 78. No, 79. Yes, procedure.
Clause 79, methods of instituting criminal proceedings. It is proposed that clause 79. Chair? It is proposed that clause 79, institution of criminal, I take it again. It is proposed that clause 79, methods of instituting criminal proceedings, stands part of the bill. Those in favor, please say aye.
Proposal in their report.
Who?
The committee.
No, they say they have not in.
The committee recommends for the words pursue be changed to pursuant. It's in order. They should have also informed us.
It is proposed that clause 79, methods of instituting criminal proceedings, stands part of the bill. Those in
We have
favor?
an issue with 80, and I will kindly will take it through.
No, we are,
We are 79.
no, we are at 79. We are yet to vote. We didn't because he raised an issue and you responded the fact that you have now reversed your decision on that. It is proposed that clause 79, methods of instituting criminal proceedings, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 80, private prosecution on certificate.
Clause 80, private prosecution on certificate under subpart 4.
Yes,
Private prosecution.
we have issue,
Yes.
clause 81D. The committee recommend for the word lunatic to be changed to person of unsound mind.
The committee's proposal is on 80 sub 1D. D. D as in director. The legal guardian or curator of a minor or lunatic. The word lunatic, they want to be changed to unsound mind. Honorable members, there's a proposal from the committee. Yes.
And also clause 83. 80 sub 3. It's within the same.
It's the same, it's the same.
Sub 3.
Sub 3.
Yes, please go ahead.
The committee recommend to include 7 working days for the grant of the certificate. This is done to give a stipulated period of time frame. Stipulated period or time frame. So we recommend to include 7 working days.
You know, honorable members, if you read 80 sub 3, it states that the director of public prosecution shall, in any case in which he or she declines to prosecute, at the request of the person intending to prosecute, grant the certificate referred to in subsection 2. There is no time frame, but for them, they want to limit it to within 7 working days. That is a week and those 2 days. Honorable members, is that okay? Yes. Next. Is that all on the 80? Yes, can you now read the amendment, how you want it to? 3. Where are you inserting the 7 working days? No, I mean on sub 3. Because the lunatic, you just changing the word to unsound. But now on 80, you are inserting 7 working days. Where are you inserting it in the clause itself? Can you read it? Yes. Sabasanjal, please.
I just want the committee to help me understand why they want to add that 7 clear working days.
Yes, that's what I'm asking them. And then to tell us where they want to insert it, then they will. What they are saying, because you know the prosecutor, the DPP, have to issue a certificate, but they don't want to leave it open-ended. Probably to limit it to, yes.
Yes, Honorable Chair. If they
Yes, Sabasanjal, then.
now, if they want to make it mandatory for the prosecutor, I think we need to look at that. It should be then optional for the prosecutor to have to do it at his. I don't mean to do it at his own time, but like if you're giving him, a period of 7 days, that he cannot give it out until after 7 days. That is where my problem will be.
No, he's not saying the DPP should give it after the 7 days. I think what they are saying is within 7 days. But yes, member for Brikama North and minority leader, then to the majority leader.
Yes, that is the insertion of that phrase, 7 working days. I think it should be the last part of the phrase, grant the certificate referred to in subsection 2 within 7 working days. Within 7 working days.
Member for Kantora and majority leader.
I think if you look at the mindset of the committee, they are trying to make sure that justice is not delayed, because justice delayed is justice denied. So once a prosecutor has chosen not to go further to prosecute somebody, and they also should be guided to communicate, because if you read the standard, it says that the director of public prosecution shall, in any case, which he or she declined to prosecute, at the request of the person intending to prosecute, grant the certificate referred to in subsection 2, which is a private prosecutor. So I want to get the gist that if they intend not to go ahead with the case, within 7 days, able to communicate to the person.
I think so that
Yes.
if the person is in jail, then once, because without the certificate, they may not. I'm not sure, but we will hear from the committee then to the Attorney General. Okay, Attorney General, please go ahead.
Yes, if you look at 4, your concern is taken care of. The public prosecutor is given 15 days. If he is not going to issue, he will give reason in writing. So you don't need the 7 days in 3. If you go to next paragraph, 4, if he says, if he declines to give the certificate, then within 15 days, he should give reason why he is not going to issue a certificate.
Maybe the amendment is important at 15, at that 4.
I think this is adequate. If you look at 4, it says, where an application for consent to prosecute is made to the Director of Public Prosecution by the person intending to prosecute, and he or she declines to grant such consent, he or she shall give his or her reasons for doing so in writing within 15 working days from the date of receipt of the application. So the DPPB has 2 weeks.
No, this one, if he refuses.
It comes to the same thing, Honorable Speaker. He has 2 weeks to accept. If he is not going to accept within 2 weeks, he should reply and indicate in writing why he is not going to issue it. It's the same.
The member for Latikunda Sabiji.
Thank you very much, Chairperson. AG, we want to be very clear of, if the AG decline to prosecute, by way of that, mean he will not prosecute the same time, the prosecutor will not prosecute. Is that correct?
No, this one, if he
the private person cannot also prosecute his or her case. Is that what we're talking about here? If you give reasons why you cannot prosecute, that means you cannot do it. But does that mean that the private person who intends to prosecute cannot also prosecute for the fact that DPP failed to prosecute?
Honorable Attorney General.
Under this current arrangement, yes. It looks like private prosecutor can only prosecute with the consent of the DPP, giving you a certificate, and you can request a DPP to issue that certificate, which should unreasonably not be denied. If he could not issue, he should state his reasons in writing. That's what I've seen so far.
Member Fulati Kunda?
No. So, honorable members, if that is the true statement, I think if the DPP cannot prosecute and indicated he cannot in writing and whatsoever, that should not bar the private person to prosecute. I think we have to insert a clause whether the DPP prosecute or not. That cannot bar the private person who wants to prosecute not to prosecute. Please, that is not a good law. It's not progressive at all.
Yeah. I think I think last session or session before last, we concluded on who should grant prosecution for criminal matters, because it's the state, it's the DPP, it must get a fair, and in accordance with the constitutional provision. Yes, member for Sabasanjal.
Yeah, thank you. I just want to refer the honorable member Fulati Kunda to 81. I think that will address his concern. 81 sub 1. A person upon whom the right to prosecute in respect of an offense is expressly conferred by law may institute and conduct a prosecution in respect of such offense in any court competent to try that offense. I think that would allay his fears.
Chair, having had the submission of the Attorney General and contributions from members, would you withdraw?
No, we will not withdraw, because if you look at 83, the Director of Public Prosecution shall, in any case in which he or she decline to prosecute, at the request of the person intended to prosecute, grant the certificate referred to in subsection 2. So we are saying we want to insert this within 7 days. The Director of Prosecution should do that.
Okay,
yes. So if you look at 4, we understand that 15 working days is there for the Director of Public Prosecution to issue this. But then sub 3, we equally want to insert this within 7 days, so that within 7 days, so that the complainant who filed these complaints to the Director of Prosecution will be in a better position to pursue if his request is not granted. That is our
Majority Leader and member for...
I just want to appeal to the committee. Hence, the subsequent clause has taken care of adequately, given 2 weeks. That will suffice. At least, we're not talking about a month here. We're talking about within 2 weeks, 14 days, 15 days to cover this thing. Knowing how, busy the courts are, giving someone 15 days. And it's not just 15 days, within 15 days, at least. So it could be even 7 days, it could be 10 days, it could be 9 days. So at least let's go by that. Thank you.
Now we will go to Ladekunda, then to the committee, and we vote.
Yeah, thank you very much.
A decision whether he can proceed to prosecute or not is very, very, very short.
15 working days.
And in
it's almost a month.
Yes, we do have files that stay in the office for more than a month for review.
You know,
He should know he's a lawyer to
When-
review this, because this is a case, sometimes if it is investigated by the police or other investigating agencies, you have a lot of evidence that you have to summarize and examine and decide, take a prosecutorial decision, whether you can file or not, you can indict or not. It's not a small work.
and then we can also probably expect in a situation where in a week, he
And
may-
it will come to find a queue,
or in
because
a-
that request will come and find other works there already. So it's not like when that request comes, we were not doing anything. When it comes, we just going to take it and deal with it.
Yeah.
This is a ministry that has a queue or so many files on the line. So if that file comes, you are now saying we jump that file and give it super priority.
And in a situation, you can also have in a day, maybe 4 or 5 requests, and you are expected to deal with all of them within a
I'm
week.
saying 24/7 we are dealing with files. So if you give this file a priority, like a private person want to prosecute, it means we put aside all work. When those kind of requests come, we just deal with that file. And within that, within 7 days, it's going to be very difficult to review an entire file and take a considered decision.
I think, yes, the member for Brikama North and Minority Leader Bakau, Chair, Oliundum, then we vote.
Yeah, I think the issue is not between clause 3 and clause 4. Substantively, the time frame proposed for amendment in clause 4 is what the minister is trying to say is already captured, even though different timing. But we have the 7 days, and that is within the 15 days. So now, since we're saying that it's already captured, that means we can forego that time frame as proposed in 3. Now, the issue of the timing in 4 is what now supposed to be under discussion. But to have the 7 days time frame in 3, since it's already in 4, we can forego that. Now, when we come to 4, then we look at it, whether 15 is okay or not, or something like that. But to have in both of them, it's not that we are discussing. Let's forego the 3 and then concentrate on what is in 4.
Now, yes, the chair of the committee, the minority leader, is suggesting we leave 3 as it is, and then when we go to 4, we look at the timing. Bakau, is that okay with you? And Chair, so now we. Okay.
He is saying that we will do that now and have that suggestion to be replaced in 4 instead of 15. Yes, 7.
Okay, member for Olindum. Now we are no more on 3 but 4.
Yes, I've been listening. I think from what we've been reading, the 15 days time that the minister is talking about, the 7 days that they're suggesting is within the 15 days already. And I think it's important for us to consider it. 7 days might not be enough to do the entire job that you want the prosecutor to do within 7 days. And now, if they cannot fulfill the 7 days, what happens next? We also have to factor that. So I think within 15 days is enough for us to legislate than, giving it a specific time of 7 days. That is my problem, honestly.
Member for Sabasanya.
Yes. I also want to support the idea posed by the Deputy Majority Leader, because based on the explanation advanced by the AG, I think sometimes we need to consider that if one person is having that huge file before him, you're giving him mandatory, a short period of time to give you something that is mandatory. I think it's very important to give him ample time to look over the file and
Thank you. Member for Latikunda Sabiji.
Thank you very much. I think what honorable members need to understand, it's not one person dealing with these files. They have a lot of state councils that I'm sure they delegate these files to on daily basis. So we are not dealing with one person here. It's the DPP mentioned, but the DPP has a lot of state councils that can treat these files as they arise. So therefore, if the committee compromise from the sub 3 to sub 4, let's also compromise. Because when it's 7 working days, the weekends are excluded. So let's have 7 working days for the DPP to react to whatever private prosecution ring to his office, then 15 days. When we say DPP, we are not dealing with one person, as Honorable Member for Sabah Sanjad said. They have a lot of state councils that these files can be given and treated for legal opinion. Please.
Thank you. Member for Kantora and Majority Leader, you have the floor.
Yes, my appeal is to the committee because they've done their good job and they've advised us. And I was wearing the lens of not bringing bureaucracy to really deprive justice or deny justice. But that's why I supported the initial proposal. But having listened to the AG and also looking at, like I said, the piles of work that is in that ministry, this is serving about 2 million Gambian. So you don't expect that place to be less busy. So, like I said, it's within 15 days. It's not saying just 15 days. It could be within. So once we give them that time frame, that they know that they're working within 2 weeks, I think that's enough. So let's also make legislation tomorrow that will also impede, its implementation. So I'm appealing that.
And in fact, depending on how soon they work on the
it's
file.
within. It can be 5 days.
It can be 3 days. It can be 2 days.
Yes.
Depending. But also,
yes.
in this, we are factoring
Exactly.
the workload and also the need to do due diligence on those files before just saying yes or no. Chair, sir.
Could we consider 10 working days rather than 15 working days? Because 15 working days, like I said, is almost like a month or more. And then, like other honorable members said, here we are not looking at one person. It's an entire office.
Chair, it's the same. 10 days, 15 days. You are not saying. I mean 15 working days or 10 working days. You are not saying that it must be after 10 working days or 15. Within, it can be 2 days. It can be 3 days. Yeah, but to give them more, so that you are avoid of them doing haphazard work also. You avoid that. You give them 15 days, you can settle for it.
This is a competent office with competent personalities, so this issue of haphazard work is not there. They can do it. They are experts. They are not like me.
No, it depends
on lawyers.
What
it's a team. It's not one person. But if
you people are overlapping. You are overlapping.
If you insist that we leave it at 15, fine. I have no issues with that.
The Attorney General is saying, even though the number of personnel and competent, nobody dispute that. But for unforeseeable circumstances, where you may have a lot of requests, unexpectedly, for example, in a week or so, but you still want to give it a minimal time frame of which they'll be able to deal with those files. I think we can just settle for it and then move on. Chair, is that okay? You're fine. Okay.
Yes, I have a question.
Yeah, please, Member Palatikunas.
I just want to ask the AG, how many state councils he has at his disposal? How many?
No, you are out of
Because these are the people who treat this fight.
No, you're out of order.
Yes, let him answer that, because that's going to guide us to give them how many days.
No, you're out of order. No. Honorable members, it is proposed that the member for lower...
Chairperson, my question is on the floor. Because we need to be guided so that we can give 10 or 15. So the people who treat this fight, we should know how many people, how many state councils.
Honorable Chair, it has no bearing on this matter. Member for
people who treat the fight, not the AG himself.
Use your mic, please.
No, I answer.
Yes.
Yes, thank you very much. I think...
Question is still on the floor. Honorable Chairperson.
On the floor to a member for Upper Fuladu.
It's pending.
Yes, thank you very much, Chair, for giving me the floor. I stand on the ground that you see,
state councils, not the AG.
Government institutions or government offices, they need to work. We don't need to give them room where people will come and suffer. 10 days is okay. They know what they are supposed to do within 10 days. 10 days is okay. And I'm going to vote in for 10 days. If you give room for that, for example, somebody coming all the way here, sit down and keep waiting, 10 days is okay. Because they have to understand that they are doing a services that is highly demanded. So there will be no excuse. We expect competent people to be there and do the job at the right time. So I'm in agreement with the 10 days.
Chair.
It is proposed that clause 80 stands part of the bill. Those in favor, please say aye. No? Oh, with minor amendment for that lunatic thing.
Chair, but you should state the amendment.
Yes, the amendment is on clause for the lunatic to 1D to unsound mind, but the rest remains as it is.
Remain as it is.
Yes. It is proposed that clause 80 as amended stands part of the bill. Those in favor, please say aye.
Aye.
Those not in favor, please say no. The ayes have it. Class.
Clause 81, private prosecution under statutory rights.
Let's continue, please.
It is proposed that clause 81, private prosecution under statutory rights. Chair, do you have anything on it? It is proposed that clause 81, private prosecution under statutory rights, stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause
Sabasanya? Your mic.
Clause 82, security to be provided by private prosecutor.
Clause 82, security to be provided by private prosecutor. Chair?
Yes, we have 82(1)(a). The committee decided
1A.
Yeah, the committee proposed that the section is open to be deleted as suggested.
You are proposing to delete the whole clause?
A. 1A.
You are proposing to delete
1A.
1.
Yeah.
That is a person upon whom. Okay.
It's only 81, 82.
Oh, 82.
82,
1A.
Yes.
The process is endorsed by the Director of Public Prosecution that he or she has sent information and has declined to prosecute the offense set out in the process. And you want to delete that?
Yes.
The powers of the powers of the DPP?
Chair.
Yes, Member for Sabasanya, you have the floor.
Yeah, I want us to be guided here by the committee, because if you delete 1A, it means you are also deleting B. Because B is a continuation from A.
Okay.
I don't know whether you are considering
what the committee have in 82.
Why, Chair, why do you want to delete 82 1A? Latikunda? Member for Latikunda, please. You have the floor. You want to take the...
I say because you want to hear it. I say we cannot delete it.
82 2A and B. 1A. The process is endorsed by the private. Okay. A private lawyer referred to instruction shall not take out of any process commencing the private unless the process is endorsed. Let me see it. Private prosecution.
Honorable members, in the absence of any further proposal on 82, can we please vote?
Can you please?
Do we vote on the clause? If you have any other proposal? No, I'm asking them if they have, what is their reason, and then do you have any other?
The issue with these two bills is that they have been with us for quite a long time, and these decisions were taken, and it's not like it was just taken yesterday. The issue with these bills, the the issues with these bills, they have been with this committee for almost 4 years, and we have had several meetings over them. Reports are taken, and they're not just taken yesterday. So at some points,
memories
cannot, personally, I cannot recall some of the reasons. So in the absence of, no.
But what he's saying, this thing, the work
What
has
I
been
want
done
to-
several years ago, about
What
4
I
years
want to
ago, so memory have faded.
conclude, what I want to conclude is, in the absence that I cannot remember, then we just leave it as it is.
It is proposed that clause 82, security to be provided by a private prosecutor, stands part of the bill as it is. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 83, private prosecution in name of private prosecutor. 3.
Clause 83, private prosecution in name of private prosecutor. Yes, Chair?
Yes, 82, 2.
No, we are on 83.
83, okay. That's okay.
83. Chair, any? No.
You said something. No, that's not it.
That's not it. It is proposed that clause 83, private prosecution in name of private prosecutor, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 84, failure of private prosecutor to appear in court.
Clause 84, failure of private prosecutor to appear in court.
No issues.
It is proposed that clause 84, failure of private prosecutor to appear in court, stands part of the bill. Yeah, member for that, please.
What I want to understand, if a private prosecutor does not appear on the day set down for the appearance, why will it be dismissed? Only one default appearance, only one. The case is.
It is proposed that clause 84, failure of private prosecutor to appear in court, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 85, mode of conducting private prosecutor.
Clause 85, mode of conducting private prosecution. Chair?
No.
It is proposed that clause 85, mode of conducting private prosecution, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 86, power of the Director of Public Prosecution to intervene in a private prosecution.
Clause 86, power of the Director of Public Prosecution to intervene in a private prosecution. Chair, you have something on?
Yes.
86.
Clause 6, 86. The committee recommends that the clause be aligned with Constitution on taking over of private prosecution. So we want the clause to be read as it is in the Constitution. So let's see. Control of prosecution. We want it to be like in 85, control of prosecution.
Member Folate Kuna Sabi.
Yeah, thank you very much, Honorable Chair. I think what the committee say is the best. This is not in spirit of the Constitution. The DPP has no power to stop any private prosecution. So I think it's better we delete this section entirely. I had to keep justice.
No, the member for Latikunda Sabi, the committee they are saying to align it with the Constitution, meaning it's a constitutional provision.
I think You know, he's a parliamentarian, he's not a lawyer. If you go to section 85 of the Constitution, the DPP has the powers.
Oh, Vice Chair, parliamentarians are expected to read the Constitution, or no?
Because the issue is, this is a constitutional provision, and you want to align into that. And if you go back to section 85 of the Constitution, it clearly states. So I just suggest my colleague to look at section 85, and that's what the committee want to align. And whether it is a constitutional or he have powers or not is already in the section 85. So check, my brother, please. Yes.
I think he's perfectly right. We always say it will be aligned to the Constitution.
Read the Constitution.
Looking at 85 of the Constitution, well, the DPP has the powers. Unless somebody has...
Yeah, member for...
Yeah, what I'm saying here, what 85 is saying, or 86 is saying, is not in conflict with the Constitution. So it's okay as it's drafted. Let's go by the text. Because DPP has the power to intervene and discontinue the case.
AJ?
The provision we read, I did not see conflict. I know there is if it's the issue of the consent to take over private prosecution is what your concern is, the provision that we are reading in this bill is not in conflict with that. And if you go to section 86 of the Constitution itself, it says an act of National Assembly may make provisions for private prosecution. And those are the details we are teasing out now in this bill. The bill 86 says the Director of Public Prosecution may, in respect of any private prosecution, apply by motion to the court before which the private prosecution is pending to stop all further proceedings in the case in order that, it's not only stopping, stop proceeding in order that a prosecution for the offense in question may be instituted or, as the case may be, continued at the instance of the state. It's taking it over, but to continue. So that's the spirit here. He's not taking it over to dispense it. So you say, stop, we are taking over from this stage and continuing. So in that regard, that's not in conflict with the Constitution. So the alignment that is being sought here, I don't understand.
Well, all what we want is, if it is not in conflict with the Constitution, then there is no issue.
It is not. It's not.
Then there is no issue.
It's
but
not at all.
We were the opinion at the time that it should be aligned to this Constitution.
Member for Banjul South.
What the committee said was, because sometimes Constitution would change. So that's the provision for now, but we also mentioned the Constitution so that in whatever case it would be reverted, the Constitution would always take precedence whenever it is amended or not. But as it is now, it was, but that was what the committee recognized and said that we should imply the Constitution so that if there is any change, it will be reflected back. That was the main reason. That was the decision of the committee. I vividly remember that.
Yes, whether it's in this act or not, because the Constitution will always prevail, and that is why even if there are provisions of any act that's contravened or is inconsistent with the Constitution, it prevails.
Yeah, we believe that the provisions here is in contradiction with the constitutional provision. If you look at 85C, provided
of the Constitution.
No, of the Constitution. 85. If you go to 85 and you look at the proviso there, provided that the Director of Public Prosecution shall not take over and continue any private prosecution without the consent of the private prosecutor and the court. So that's why we are suggesting that this clause to be read with.
So Honorable Speaker, that's fine. That is why he is coming by way of a motion. That's the consent that he is taking. That's why he says the Director of Public Prosecution, in respect of, in respect of any private prosecution, apply by motion. All right? But in any event, we can reach a compromise. We can say the Director of Public Prosecution may, subject to the Constitution, and then we continue. And that will fix the problem.
Hello, Chairperson. Yes.
Yes.
You see, this is the point I was trying to raise ever since. And AG and others understand, but some of you just confuse yourself. This was the.
We never
point
saw
I
this
wanted
coming,
to
please.
raise without the consent. So we cannot, this section, let's delete this section. This section is very irrelevant here. This was my issue at the beginning. Chief Justice and others who are
You
not
see,
illiterate.
go back to school and learn lawyer.
You guide yourself, you are not a bit more confusing than. Huh?
It is proposed that Clause 86, power of the Director of Public Prosecution to intervene in a private prosecution as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 87, cost in respect of private prosecution.
Clause 87, cost in respect of private prosecution. Chair?
No issues from the committee.
It is proposed that Clause 87, cost in respect of private prosecution stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 88, expenses of a private prosecution.
Clause 88, expenses of a private prosecution. It is proposed that Clause 88, expenses of private prosecution stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 89, cost of accused in private prosecution.
Clause 89, cost of accused in private prosecution.
No issue from the committee.
Nominated member.
Yes,
Popana.
Honorable Chair, I'm looking at Clause 81 and Clause 89. The fundamental difference there is one, Clause 81 is with regards to the Director of Public Prosecutions, and Clause 89, we are talking about private prosecutions. My issue here is with regards to the...
81 of which document? The same document?
The same document.
Okay.
My issue there is with regards to compensation. In Clause 89, it reads that where in a private prosecution other than a prosecution contemplated in Section 81, the charge against the accused is dismissed or the accused is acquitted, or a decision in favor of the accused is given on appeal, the court dismissing the charge or acquitting the accused or deciding in favor of the accused on appeal may order the private prosecutor to pay to such accused the whole or any part of the costs and expenses incurred in connection with the prosecution or, as the case may be, the appeal. So, I want to understand why is compensation kind of considered in case of private prosecution, but when it comes to prosecutions which have been led by the Director of Public Prosecution, there is nowhere that it is provided.
Yeah, Attorney General.
The state has the inherent right to protect everybody. And in protection of everyone, the state is vested with the authority to prevent crime. And it's part of crime prevention that you prosecute offenders. And by doing this, from investigation right to prosecution, we are incurring state resources. So, and it is presumed to be done in good faith. But even for the state, if the prosecution is believed to be malicious, people who have been prosecuted have a recourse to go after the state for malicious prosecution. But it's even more serious, where the state looks into the matter and considered it not meritorious to proceed to prosecute. And you as a private individual still insist that you want to prosecute somebody. Therefore, you should assume the risk. If you take that person through the trauma of criminal trial, when you have been advised by a Director of Public Prosecution that I don't see any case in this, but you insisted as a private individual that you want to prosecute your fellow private citizen, then you take the risk. If you take him through the trouble and it turns out that the case is not good, you should be willing to, in the very minimum, compensate him for the cost and the trouble that he took to go through that, to defend in that suit.
And the trauma.
And I think that is fair.
It is proposed that clause 89, cost of accused in private prosecution, stands part of the bill. As it is, those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 90, taxation of costs.
Clause 90, taxation of costs.
No issues.
It is proposed that clause 90, taxation of costs, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 91, limitation of right to institute private prosecution.
Clause 91, limitation of right to institute private prosecution.
We have a list.
Yes, committee chair.
91F, the committee recommends for attempted rape. In this clause be deleted for it to be in connection with the Sexual Offences Act.
In connection or in line or in
connection.
Conformity?
That's what they write on here. Anyway, the committee is recommending for attempted rape.
What the committee is saying is to delete attempted rape in this, since this clause, for it to be this is in connection with the Sexual Offences Act. Not so we are saying that this is catered for in the Sexual Offences Act. So we can delete it from this criminal procedure. The F,
yeah,
91F, since it is taken care of by the sexual.
In which section in the Sexual Offences Act?
Come again?
Do you have the section in the Sexual Offences Act where it is catered for?
Materially here, no, but it's maybe the office of the AG will help. They have acts there, can just make reference to it. If it is adequately taken care of by the Sexual Offences Act.
I think this is to say that these areas they cannot prosecute. Yes, I think that's what.
This is limitation of time.
After 20 years.
Generally, there is no limitation of time for crimes. Once you are suspected of having committed a crime, you can be prosecuted at any time during your lifetime. They don't expire. Crimes don't expire. They don't have statute of limitation. But for private prosecution, we are now proposing a limitation for that, not for the public prosecution, but for a private individual who intend to prosecute somebody for these crimes listed, you have 20 years to do so. After 20 years, your right to exercise private prosecution lapses. But when it comes to the state's right to prosecute, public prosecution, that doesn't expire. It is the right to privately prosecute these offenses that is going to expire after 20 years. And I think that's fine.
It should not be even deleted. It should be part of it. The rape should be part of it.
Is it clear?
Yeah, it is. Okay. It is since because what we thought was it is already taken care of, but in the Sexual Offences Act. But since
no, this one here is time limitation. Yes, member for Sabasanjal, then Kantora.
Yeah, that was exactly what I wanted to raise. I believe that the time is very limited.
Member for Kantora and Majority Leader.
To appeal to the committee again to withdraw that proposal, because probably, yes, not justice. Look at this man, say justice. I don't know, were you opportune to have representative from the Minister of Justice during your, yeah.
Huh? Yes, Sabasanjal.
I'm suggesting that at least we increase the time to 30 years, considering the lifetime of people living in the Gambia. You know, yeah. The reason is because you might be in a situation wherein you have a dictatorial system of government wherein you will not be able to have the opportunity to prosecute that individual. Imagine if somebody did something wrong in 1994 or 1996 or 1997, thereabout, and then now I have the opportunity to take that into prosecution. And you've given me only 20 years of age. After 20 years, I cannot go ahead with prosecution. Give me a chance, give me a chance.
Okay.
Give me a chance to learn. Now, you look at the lifetime of people, at least 65 years of age, you know. So if you raise the bar to at least 30 years, I think that is more feasible than only 20 years.
Member for Kantora and Majority Leader.
Just to add and allay the fear of our comrade that his fears will be allayed, there is a private prosecution in place, but of course, if that 20 years elapsed, you have other option, that is public prosecution to take place. So I think we will consider that. Thank you.
Does that answer your concern?
No. What about if the public is not interested on going ahead with that?
No.
What happens then?
No, what he's saying,
yes.
After 20 years.
Allow him. No, wait. Honorable Chair. What I'm saying here is, if the public is not interested.
No, what he's saying.
On going ahead with that prosecution, what happens then? So I don't want it to be just, inclined to the public. No.
Even after change of government, what this means, after 20 years.
Change of government 2026.
Point of order.
Yeah, point of order by Majority Leader, member for Kantora.
Honorable Speaker, the member is going out of order. Rules of I'm rising under Standing Order 17, behavior of members. No members shall deviate from the topic of discussion in the chambers and shall not unseemly interrupt the proceedings of the Parliament. Thank you.
Thank you. Order sustained. Honorable member, please refrain from such. Member for Atakunda. Yeah. Nomination member Kebalan Fofana, you have the floor.
Honorable Chair, having listened to the Attorney General, for me, my question would be the rationale behind that provision which attaches an expiry on crimes when the intent is there to prosecute them on private basis. What is the rationale behind it?
You see, private prosecution is not the best option for prosecuting crimes, honestly. I mean, it's only a window that is created just in the unlikely scenario where somebody thinks you have got a good case to prosecute, and for some reason, maybe the state prosecutors chose not to prosecute, and you believe in the case so much. These things come very rarely, even after each order. For 50 issues that have happened 50 years ago, you have to put some limitation at some point when a private citizen can go after his fellow private citizen without the involvement of the state. For how long can that go on? In fact, for me, if you ask me personally, which I'm not supposed to express my personal opinion, 20 years might even look so long. Because that means I can sit down here and hear that you have been involved in something 20 years ago, and probably if I have the resources, engage private investigators, gather, build the file, and come after you for something you have done 20 years ago. Where if the state doesn't want to come after you, I can build the case and then prosecute you privately. I mean, at some point, I think it's important we allow it, but we control it also.
Yeah, member for Sabasanja.
Yes, this might be something which is of a wound on me. And to allow me to heal, you give me the opportunity to go ahead prosecuting.
For 20 years. Yes. If you sleep on your rights for 20 years, what else The state have given you the opportunity and gave you 20 years to exercise your right. After 20 years, the state said at that point, it's okay. If you cannot go after somebody for 20 years, I mean, we close the door.
It is proposed that, Sabasanjal, what about within that period of 20 years? The system of government that was put in place did not allow you as an individual to go ahead prosecuting that individual based on the level of protection that is given to that individual within a period of 20 or 22 years. And after that period, you now have the opportunity to go ahead with prosecuting. But now, still, because during that time, you were not given that opportunity, and now the state is not interested on going ahead with prosecuting, and you're still sitting there with your wound, and you still want to get healed. I think I should be given the opportunity to go ahead with prosecution.
Okay, go ahead.
Member for Lower Badibu. Yeah, Attorney General.
I'll say we propose and we believe 20 is reasonable, but this is Parliament. If you want to open it up to 100, that will be the law. But really, I mean, we looked at so many considerations and we think 20 years is reasonable.
It is proposed that Clause 91, limitation of right to institute private prosecution, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it, Clerk.
Clause 92, form and contents of summons.
Clause 92, under Part 5, issue of summons. 92, form and contents of summons. It is proposed that Clause 92, form and consent of summons, stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 93, service of summons.
Clause 93, service of summons. It is proposed that Clause 93, service of summons, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 94, service when person summoned cannot be found.
Clause 94, service when person summoned cannot be found. It is proposed that Clause 94, service when person summoned cannot be found, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 95, procedure when service cannot be effected.
Clause 95, procedure when service cannot be effected. It is proposed that Clause 95, procedure when service cannot be effected, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 96, service on servant of government.
Clause 96, service on servant of government. It is proposed that Clause 96, service on servant of government, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 97, service on a company or body corporate.
Clause 95, service on a company or body corporate.
97.
97. Clause 97, service on a company or body corporate. It is proposed that Clause 97, service on a company or body corporate, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 98, where summons may be served.
Clause 98, where summons may be served. It is proposed that Clause 98, where summons may be served, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 99, proof of service when serving officer not present.
Clause 99, proof of service when serving officer not present. It is proposed that Clause 99, proof of service when serving officer not present, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 100, power to dispense with personal attendance of accused.
Clause 100, power to dispense with personal attendance of accused. It is proposed that Clause 100, power to dispense with personal attendance of accused, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no.
Clause 101, proclamation for passing absconding.
Clause 101, proclamation for passing absconding. Yes, Chair.
Clause 101.1. The committee recommends that the bracket be replaced with commas. Yes, that's all.
Clause 101, sub 1, the committee is proposing to replace the bracket with comma. That is, if a court has reason to believe whether after taking evidence or not, you want that okay, because you are, I thought you were talking about to replace it or to remove the bracket and replace it with comma. And 101.2D, use your mic, sir.
Yeah, 101.2D, the committee recommends to delete daily newspaper and add 2 newspapers of widespread circulation and also gazetted.
You know, the court may, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper. Here meaning 1, but the committee is saying at least 2. And then add widely, I don't know, yeah, you will, AG? Instead of a daily paper, they say 2 widely circulated. Not new papers, only 2 daily papers that are widely circulated. Yes, so because 2, maybe you are only limiting it to 2, or because like in our standing orders. Yes, member for.
I think the daily should be dropped because we don't have a newspaper that is daily. We have newspaper at certain days. We don't have daily newspapers. I think the daily.
No, Gambia we do.
Not all the time. Sometimes we have Monday, Wednesdays, and Fridays. We don't have a newspaper that is daily.
We have in the Gambia currently we have several that comes 5 working days. We have the Points, the Standard, the Foroya, the daily, the Gambia daily. Because okay, now member for Central Banjul South.
Why don't we just say widespread rather than daily? Because there might be a time when we might not, because that's very restrictive, daily.
The member for Serekunda.
What I want to say is, by UNESCO standard, any newspaper that comes out 4 times a week is a daily newspaper.
Let's go by the amendment that 2 widespread newspapers. Yeah, instead of 1, let's be 2. That's the amendment there. That's all.
So now the 2.
2 widely spread newspapers.
At least 2.
At least yes, at least 2.
Chair, the member for Kantora is proposing to add a word to say at least 2 widely spread. Okay. It is proposed that which Close? Sub 1 or? Okay. Not that any person against whom a warrant has been issued by it cannot be executed. Huh? Man, I'm not understanding him. I'm not getting him. Okay, by it has absconded or is connecting, concealing himself.
Against whom? Represent whom?
Yeah, that's the court. No, if a court has reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by it has been a warrant has been issued by the court, has absconded, or is concealing himself or herself so that the warrant cannot be executed. Is correct? It is proposed that Clause 101 proclamation for person absconding stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Yeah. Clause 102, attachment of property of person absconding.
Clause 102, attachment of property of person absconding. Yeah?
We have an issue.
102, sub 2. 102, sub 2. The committee recommend for comma. Okay. 102. The committee recommends for the amendment of the heading, attachment of property of person absconding. The committee recommends for the comma after to be deleted, the comma to be deleted, I think, you know. No, we
102. Wait a minute. 102. Chair, you're reading the 102. It said the committee recommends for sorry, 102.
That is sub 2. The committee is recommending the comma in sub 2 because you have the 2 in bracket. Because 102, 2, that 2 represents sub 2, I think. Yes, it sounds more, it makes more sense. I think the sub 2 they are referring to, the amendment they are proposing should be on sub 2. Chair, can you, yeah. Huh?
1022.
Yes.
Yes, that's it. And then it goes down to say
says,
add 4 before the in the last paragraph of the clause.
Yeah, because it's saying the committee recommend for the comma after to be deleted and to add.
That's yes, and that's what should be deleted. That's what we are referring to. This is a 4-year document, so you have to bear with us.
I think what they want to say, the comma after to be is to be.
Proclamation is to.
They have to read this. They have to read the section. Read the section, and then we will know what we are talking about.
Honorable Care.
Let's read the
Honorable
text.
Care.
102.
Yes.
102.2.
Okay. Oh, sorry.
102.2. I think it says where at the time of the issue of the proclamation, comma, the court is satisfied by affidavit or otherwise, comma, that the person in relation to whom the proclamation is to, comma, B. I think that's what we are referring to. This comma.
I think that comma
should be removed.
That's what they are saying.
Yes.
And then my problem is now you said an at 4 before the article D. But there is no article D here. That's the problem. I think now let's look at the second line, where at the time of the issue of the proclamation, the court is satisfied by affidavit or otherwise for that. Maybe they want that to come out to be deleted, or otherwise for that person.
The last paragraph of the clause. The last paragraph of the clause starts with if. Or it may order the attachment simultaneously with the. I think this is the article D we are referring to.
A member for the Cameron.
Are we together? They're not together. Okay. Now go to the last paragraph of the clause. The last paragraph, which starts with it may. Have you seen that? It may order the attachment simultaneously with, then you make for the issue. For is supposed to insert for between with and D.
Or is 1 or 1 2 D? No.
The paragraph of 2 ends here. This is what it may order the attachment simultaneously. This is what they are referring. There wasn't 4 here before.
I don't think that's what the committee was looking at. Because, you see, when you look at 102, they're saying only 2. But they have not informed us whether it's 2A or B. That means they are referring to 2. 1 or 2, 2. Because if you go further,
guide you, Chair.
if you read,
What will guide you is when it says in the last paragraph of the clause. And that's B. Last paragraph of the clause.
no, 2 also is a clause. The last paragraph of the clause is be issued is about to. Because they are saying 2. They don't say in 2A or 2B. They say 2. They are not saying 2A.
Whether we are looking at the same thing. But for me, the last
We are-
paragraph,
we-
the last paragraph of 102
Is this one?
is where it says it may. 102, that is 102.2b. That's the last paragraph of, that's how I construe it. And that's where you can find Article D.
Continuously with the issue 4.
But since this is not as Honorable Latikunda would say, this is just grammar. We can just move on. Let us not waste our time over grammar. So it will be clean. Chair, it's not an issue of facts. So we can move. Let's move.
Chair, yeah, it can be in that view.
Chair.
Honorable Chair.
Yeah, before, okay.
Yeah, this particular
minority, can I just for the technical so that before I come to you? You see, they are saying 102, you look at 6. Yes. Second, yeah, that's technically maybe the last paragraph, maybe, I don't know, of 2. You look at the last line, second to last line, immediately sale thereof. And in such cases, the proceed of the sale that's the second line. Let's go to the second line of 6. A perishable nature. The court may, if it thinks it expedient, order, then to add 4 between order and immediate. Order for immediate sale thereof. You are right. The article D is where? 2B.
Chairman.
2B. The article D is in 2B. 2D. 2B, okay. D. Okay. Yeah, 2B.
Yes.
After remove there is comma.
Yes.
The minority saying we remove that comma, then you read it, and then minority?
Remove, then they want to insert the 4 before the article D.
Okay, that is property. Where is the article D? Jurisdiction of
the article D whole. Huh?
Okay, remove whole or any part.
Remove for the whole or any part of his or her property.
Remove for whole.
Madam is shaking her head.
Chair.
Yes.
I just want to say that I will apologize before saying it, but the committee is not giving us guidance. So I'll propose that in the future, if the committee is making amendments, let them rewrite the entire clause and tell us so that it will read us. We know what it is. Because everything we are doing here is a perfect guess. And if we go by what the minority is proposing, I don't know whether it will even change the substance of the provision. The whole and for the whole, there might be difference in legal terms. I stand to be guided. So I strongly believe we should just skip this particular one. and allow the drafters to do their work.
You know, there was earlier on a disclaimer made by the chair because he told us that, you know, this was done about 4 years ago, and then memory is fading. So
That's
what
Chair, that's why I'm proposing. If at all they rewrite at that time, they did rewrite the clause itself.
Okay.
I think it may not necessarily.
Can I complete?
Yeah, finish, please.
Yes. Parliamentary rules are subject to changes. And the work we are doing today, we don't know who might complete it tomorrow. And those people deserve to have the information in full so that they can utilize it. You know, instead of saying insert the between this and that, you can say insert the word the in clause 102 so that it read as you bring the entire clause.
Okay.
Then no matter what happens, no matter who comes tomorrow,
they
would know where it is and they
flow.
would know what to do and the flow would be there. But when you say insert the or delete comma or add full stop, you stop. Then we'll start guessing.
Yeah, it become a challenge.
Yeah, it's
Not
a challenge.
Chair,
Yes, thank you.
I agree, and that is not only maybe to this committee, but to the entire committee, because no committee has never reported that way, the way he suggested. But it is a new innovation. It's good. We can adopt it.
Thank you. Minority Leader and Member for Pirkama
I think the issue is not about the memory here. I think the issue has to do with drafting. It's different from the one that we were dealing with yesterday. But the references are made, they are specific. You refer to the particular clause and then the subclause, it will be very easy. So where here, for what we cannot understand, which clause or subclause they are making reference to. I think that's what is the issue. So in future, we can look at that, especially when we are adopting reports. It's an oversight.
Now, what do we do with this one? It looks like all of us, nobody can. What do we do? Do we leave it as it is or what?
Yeah,
in fact, that's what I have suggested.
The substance as such. I don't think.
We leave it as it is.
Yes.
Because this is just grammar. For
Okay.
me,
Sorry, Member for Jara Central, please, you have the floor. I apologize.
Okay, thank you very much for that apology. Chair, I think the most befitting amendment on this particular clause, as the committee has recommended, is the removal of the comma. After removing the comma, the four that they are recommending for us to amend, it's not feasible. So I go by the honorable member for nominated member for Kebalam Fofana, as has indicated.
Yeah,
let's do away with that amendment and then we proceed.
Yeah, the chair has conceded on behalf of the committee.
Thank you.
Thank you. It is proposed that clause 102, attachment of property of person absconding, stands part of the bill as it is. Those in favor, please say aye. Those not in favor, please say no. That is it.
Clause 103. Clause 103. Warrant after issue of summons.
Clause 103 under subpart 6, issue of warrant of arrest.
no, it's no issue.
Clause 103, warrant after issue of summons, stands part of, it is proposed that clause 103, warrant after issue of summons, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. That is it.
Clause 104, disobedience of summons.
Clause 104, disobedience of summons. It is proposed that clause 104, disobedience of summons, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. That is it.
105, form, contents, and duration of warrant of arrest.
Clause 105, form, contents, and duration of warrant of arrest.
105, the committee recommends that the letter S be deleted from the word contents. So it will read content.
Okay, that's the capsule.
Yeah, the capsule.
Their proposal is contents to delete the letter S. It is proposed that clause 105, form, content, and duration of warrant of arrest, stands part of the bill as amended. Those in favor, please say aye. Those not. Those not in favor, please say no. The ayes have it.
Clause 106, court may direct security to be taken.
Clause 106, court may direct security to be taken.
Yes, this issue is a similar issue. I remember when this bill was before us, we asked redrafting, and then the chair then and the members said we should have done the follow-up. And we stood our ground to say, no, we did this with the ministry, so, and they have the report. So since we agreed on it, there's no need for us to follow them for any redrafting. So it's a similar situation. So if it is done, fine. If it is not done, the ministry can let us know, and then we move ahead.
Huh? Yes. Attorney General.
I really don't have any issue with the paragraph the way it is.
Yes. It is proposed that clause 106, court may direct security to be taken, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 107, warrants to whom directed.
Clause 107, warrants to whom directed. It is proposed that clause 107, warrants to whom directed, stands part of the bill. Those in favor? Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
108, clause 108, execution of warrant directed to public officer.
Clause 108, execution of warrant directed to police officer. It is proposed that clause 108, execution of warrant directed to police officer, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 109, person arrested to be brought before court without delay.
Clause 109, person arrested to be brought before court without delay. It is proposed that clause 109, person arrested to be brought before court without delay, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 110, where warrant may be executed.
Clause 110, where warrant may be executed. It is proposed that clause 110, where warrant may be executed, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 111, procedure on arrest of person outside the jurisdiction.
Clause 111, procedure on arrest of persons outside jurisdiction. It is proposed that clause 111, procedure on arrest of person outside jurisdiction, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 112, irregularities in processes.
Clause 112, irregularities in procession. On 112, irregularities in processes. It is under subpart 7, miscellaneous provisions regarding processes. It is proposed that clause 112, irregularities in processes, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 113, power to take reconnaissance for appearance.
Clause 113, power to take reconnaissance for appearance. It is proposed that clause 113, power to take reconnaissance for appearance, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 114, arrest for breach of reconnaissance for appearance.
Clause 114, arrest for breach of reconnaissance for appearance. It is proposed that clause 114, arrest for breach of reconnaissance for appearance, stands part of the bill. Those in favor, please say aye. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 115, power of court to order prisoner to be brought before it.
Clause 115, power of court to order prisoner to be brought before it. It is proposed that clause 115, power of court to order prisoner to be brought before it, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 116, provisions of this part generally applicable to summonses and warrants.
Clause 116, provisions of this part generally applicable to summonses and warrants. It is proposed that clause 116, provision of this part generally applicable to summonses and warrants, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 117, search of premises.
Clause 117, search of premises under subpart A, search warrants. 117, search of premises. Chair?
Yes. The 1173. The committee recommends that the word dishonestly before punishable to be ratified as dishonesty. Dishonesty, yeah.
Yeah.
Dishonesty is
Sub 3, the authority under subsection 2 shall not be given unless the person in respect of whom the authority is to be issued has been previously convicted of receiving or retaining stolen property, or of whom, or of some other offense involving fraud or dishonesty. Dishonestly punishable with imprisonment. They want to delete L. It is proposed that clause 117 as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 118, when such warrant may be issued and proceedings thereunder.
Clause 118, when such warrant may be issued and proceedings thereunder. It is proposed that clause 118, when such warrant may be issued and proceedings thereunder, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 119, execution of such warrant.
Clause 119, execution of such warrant. Yes, Chair.
Clause 119(2). The committee recommends for deletion of justice for the peace. Justice for
the peace to be deleted.
Yes.
Section 119 sub 2. Notwithstanding subsection 1, a magistrate or justice of the peace, they want justice of the peace to be deleted. Attorney General.
I think we have got sufficient magistrates now. I think the time when we will require justices of the peace to do this kind of work, there were no. But nowadays, I think every part of the country we've got magistrates there. But it really can serve a purpose because it makes access to these authorities wider. So I don't know what is the risk, but if we leave it there, it means, getting this authorization can be easier. It's just to support law enforcement. If a law enforcement officer sees something and wants to take steps, but by law for his intervention in that situation requires an authorization from a judicial officer. In the situation where a magistrate is not available, if a justice of the peace is available, the justice of the peace can endorse the warrant for him. It's in the public interest, definitely. It's just in the public interest.
So, lawyer wants to. So let's go.
Chair. Chair, I think the minister agreed with the justification. that shows that they were part and parcel of it. But then he is now saying that it's still an advantage. But he agrees that now we had more than enough magistrates. But then...
no, even in other cases, Honorable, we respect
conclusion.
the committee's job.
No, I agree with your conclusion.
Really,
I'm just saying, this is just to justify that your team was with us throughout. That's why you exactly defended, say, yes, because we have enough just magistrates. But then having them also there would have more access to justice. I have no issues with that.
Honorable Chair, he's provoking, please.
Okay, now, when you look at sub 2, the committee has agreed with the Attorney General to leave it as it is. But after magistrate or justice of the peace, whether we can justice of peace or we can without article. Huh? With article or without article? With article. It is proposed that clause 119, execution of search warrant, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 120, persons in charge of closed place to allow entry thereto and exit therefrom.
Clause 120, persons in charge of closed place to allow entry thereto and exit therefrom. It is proposed that clause 120, persons in charge of closed place to allow entry thereto and exit therefrom, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no.
Clause 121, detention of article seized.
Clause 121, detention of article seized.
Since we have agreed to leave it at 119, so we'll maintain what is in the...
It is proposed that clause 121, detention of article C, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 122, provisions applicable to search warrants.
Clause 122, provisions applicable to search warrants. It is proposed that clause 122, provisions applicable to search warrants, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 123, general entitlement to bail.
Clause 123, general entitlement to bail. Yes, Chair.
Clause 123. The committee recommends that broad be spelled correctly as broad and B added after parts.
And then
the spelling and the addition of B.
Yeah. Brought before a court, and he or she shall, subject to the provisions of this part, brought, be entitled to bail. It is proposed that clause 123, general entitlement to bail as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 124, the grant of bail by courts.
Clause 124, the grant of bail by courts. It is proposed that clause 124, the grant of bail by a court, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 125, bail where a person is charged with a capital offense.
Clause 125, bail
Chair.
where a person... is charged with capital offense. Committee?
Yes, 125-2A. The committee recommends that it be amended as notwithstanding paragraph A, B, and C. Judge may grant bail taking into consideration the circumstances before him or her.
What is it? Why?
Hmm?
Basically change the entire
125.
125-2A.
125-2A. What is this? Huh?
They want to amend it all. That means this.
So, can you read us your paraphrase clause? Honorable Member, Chair, can you read us the paragraph that you are suggesting? Can you read the paragraph to align it with how you want it to flow?
So I can fully remember is we're saying that you start the paragraph with notwithstanding, and that goes for A, B, and C.
Or the paragraph should be started with notwithstanding ill health of the applicant, notwithstanding extraordinary delay, notwithstanding any other circumstances. Nominate member ke walang fofana.
Yeah. Thank you, Chair. My only concern with this is, sub 2C, where it says that any other circumstances that the judge may, in the particular facts of the case, is considered exceptional. Honorable Chair, we agree on the basis of ill health. And the other provision there is when we have unnecessary delay.
Banjul South, migrate back to your seat or somewhere else. I don't know what you people are discussing there. No, remember, please continue.
I can proceed. If you look at section 125, it is telling us that, like, individuals who are charged with offenses punishable with life imprisonment can be granted a bail by the High Court. And it also says that they can be granted bail under exceptional circumstances, which is defined as A, if at all they are of ill health, and he gives the conditions there, and B, where there is unnecessary delay, which also a time have been attached, meaning if at all the proceedings have exceeded 1 year. But after that, the doors were open to leave it at the discretion of the judge. So that is my problem. That is the only concern I have, where it states that any other circumstance that the judge may, in the particular facts of the cases, consider exceptional. Now we are leaving everything at the discretion of the judge after bringing two safeguards. One with regards to health, and the other time with regards to what? The undue time. And these are the two instances which might be exceptional. So, we want to be guided by the experience of the AG and the legal team. If at all other circumstances can come up, so that we may know, before allowing it to the discretion of the judge, which might sometimes end up having some unintended consequences.
A member for Kantora and Majority Leader.
Yeah, I want the committee, because the committee if you look at A, ill health of the applicant, which is confirmed and certified by a qualified medical practitioner employed in a government hospital, showing that there are no medical facilities to take care of the suspect. Illness by the authority detaining him. So is the committee also recommending slash her there? You know, it says only him. So you want us, him or her, to slash her there. Okay. On the A. So, extraordinary delay in investigation. So, okay, now, look at
Because
A.
what they are saying, this extraordinarily comes after every sub-clause. Extraordinary ill health. Sorry, notwithstanding. Yes,
okay.
Notwithstanding ill health. Then notwithstanding extraordinary, notwithstanding any other.
Yeah, no. What they are saying also, why limiting it to only government hospital? It limited that ill health of the applicant, which is confirmed and certified by a qualified medical practitioner employed in a government hospital. Can a private hospital also certify?
No, it says includes, meaning there are other circumstances that they have not.
I understand. It said that it's like they are only accepting a certificate by a competent employed staff in a government hospital. How about you have some private hospital who are also offering similar?
Now, the Attorney General, please, you have the floor.
I see the concern of the members. So I think we could substitute includes and replace it with means.
Okay.
And then in the list, if you want to reduce the discretion of the judges, we could also even probably remove C. Because generally, these are very serious offenses. As we stand right now, they are not even bailable. If we want to be progressive and want to make them bailable, we should make them bailable under restricted conditions. And ill health is genuine. If investigation is taking too long and somebody is in remand for over a year, I can understand that also the person should be given bail and so on and so forth. But other than that, if you say it includes, it means this and any other, which the judge can use any other reason. And C is also giving the judge a latitude to consider anything as extraordinary. If we are going to move away from non-bailable and make them bailable, let's make them bailable, but let's control the conditions under which they could be bailable.
So that's why,
because this, I think, public interest is at stake.
That's what I recommend for government.
Yes. So instead of includes, we can substitute that to say means, and that means we are defining. We are not leaving the definition wide open.
Yes.
And then we maintain A and B, and probably do away with C.
Yeah, because as age indicated, as it is, it's open-ended. You remove includes and you add means, then you delete C. Members, are we in agreement? Yeah, the proposal is. Janjamuri said no. What is no? No. You are saying no, or you want to take the floor?
No, because I feel you are drawing to a conclusion, and I have a concern with regards to.
I have intended to give the floor after, but I forgot because I saw your tag earlier.
So this is why I'm reminding you with that gesture. Yes, I still have a concern that I would like the minister to clarify here. That is on 2A with government hospitals, and I don't know why are we exempting private practitioners in terms of this very clause.
Currently, even with government hospitals, we are beginning to see problems. We have started seeing even forged medical certificates, people applying for bail, and they bring forged medical certificate. Right now, I've referred so many cases for the police to investigate. So people take advantage of this. With all due respect to private facilities, I don't intend to bring them into any form of disrepute. But because this is prosecution, let them go to a public facility. It's just like if you want to recommend you for abroad medical treatment, private hospitals could give you a certificate, but we say it must come from a public facility. So I think we would recommend that. certificate be obtained from a public facility.
Member for Banjul South?
I was going to concur and the medical board.
You said you sit properly. Please, now, yeah. Banjul South, you have the floor. Banjul South, please.
I concur because normally it should even be the medical board that should approve these things.
Okay. Janyamura, you okay with that?
Chair.
Yes.
I think this could still give us an opportunity to improve on some of our systems by not exempting the private practitioners, because as much as I may agree with the Honorable Minister, but then in the other hand, I would also think our private facilities in terms of health delivery seems to be way better than our government facilities. So, yeah, that's the truth, Majority Speaker.
Majority Speaker? As the Honorable Member, you could not have put it better that we want to improve, because the Attorney General have told us they have realized some loopholes, and now they want to improve by limiting it only to public health institutions. Like, for example, he cited, even if government have to give you medical treatment outside, you must undergo medical board. And the member for Banjul South, in fact, not only is suggesting not only from government health facilities, but from the medical board. And I think with that, we may want to ensure that, as the Attorney General has indicated, not putting any private practitioners into disrepute, but to concentrate it on state institutions, which we will believe that it will come out as expected.
And specifically the medical board, you meant?
In fact, no, she is suggesting to go further, to say it must come from the medical board. That's her proposal, but it doesn't.
Yeah, I might even agree with her proposal with a medical board than just leaving it with state health practitioners.
Thank you. Member for Jara Central, Honorable Attorney General, I'm not sure if I've taken note of Banjul South and Janyamure. Janyamure have withdrawn and tried to marry his contribution with that of Banjul South. Jara Central.
Yes, thank you very much, Honorable Chair. Honorable Chair, I would just want to be clear here as to the recommendation that came from the committee, where it says, I mean, as notwithstanding paragraph A, B, C, yes, A, B, and C, a judge may grant bail taking into considerations the circumstance before him or her. As to where are we going to insert this? No, yes, but I'm not clear with it.
No,
I have the right to.
Yeah, you have the right.
Yes.
Yeah, you are right. No, they said,
yes,
from the beginning of each clause, notwithstanding ill health, notwithstanding extraordinary, notwithstanding any. But now they have gone further to agree that to delete includes, and to say meaning, then as well to delete C. Yes, and him up here. And then there is now what we are dealing with is a proposal instead of states instead of government practice, 2A, government hospital, there's proposal to say from from the medical board, from government medical board. Or you want to limit it only to okay, medical hospital, that's fine. Honorable members, so that it's not also very cumbersome. It is proposed that clause 125, bail where a person is charged with a capital offense as amended, which of course to delete includes and add meaning, and then delete C, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 126, bail where an accused person is charged with offense exceeding 3 years in imprisonment.
Clause 126, bail where an accused person is charged with offense exceeding 3 years imprisonment. It is proposed that Clause 126, bail where an accused person is charged with offense exceeding 3 years imprisonment stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 126, bail where accused person is charged with offense not exceeding 3 years imprisonment.
That's clause 127.
Yeah, 127.
Clause 127, bail where accused person is charged with offense not exceeding 3 years imprisonment.
Yes, we have an issue. We have an issue. And
the committee chair have some issues.
The committee recommends for the word defendant be changed to accused person. If you look at the caption, it says bail where accused person. Then you go down and say in any other circumstances other than those referred to in section 125.
In line with the hearing.
Come again?
Instead of defendant, to bring it in line with the hearing. Attorney General.
For consistency, we can maintain accused person.
It is proposed that clause 127, bail where accused person is charged with offense not exceeding 3 years imprisonment as amended stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 128, power of court to order person in custody to be brought before it.
Clause 128, power of court to order person in custody to be brought before it. It is proposed that clause 128, power of court to order person in custody to be brought before it, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 129, general provisions as to reconnaissances.
Clause 129, general provisions as to reconnaissance. It is proposed that clause 129, general provision as to reconnaissances, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 130, release from custody.
Clause 130, release from custody. It is proposed that clause 130, release from custody, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 131, deposit in state of reconnaissance.
Clause 131, deposit in state of reconnaissance. Chair, it is proposed that clause 131, deposit in state of reconnaissance, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 132, variance of reconnaissance.
Clause 132, variation of a reconnaissance. Clause 132, variation of a reconnaissance. It is proposed that clause 132, variation of a reconnaissance, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 133, application for discharge by sorties.
Clause 133, application for discharge by authorities. It is proposed that clause 133, application for discharge by authorities, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 134, reconnaissance in respect of minors.
Clause 134, reconnaissance in respect of minors. It is proposed that clause 134, reconnaissance in respect of minors, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 135, persons bound by reconnaissance absconding may be committed.
Clause 135, persons bound by reconnaissance absconding may be committed. It is proposed that clause 135, person bound by reconnaissance absconding may be committed, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 136, forfeiture of reconnaissance.
Clause 136, forfeiture of reconnaissance. It is proposed that clause, Chair, they have something? 136.
136.4. The committee recommends for
Without hard labor, to be deleted. And I'm without hard labor.
Said this several times here. Anytime the issue of hard labor, we say just sentence the guy. Simple as that. Unless you think otherwise.
136.4. If the penalty is not paid and cannot be recovered by attachment and sale, the person so bound shall be liable by order of the court which issued the warrant to imprisonment without hard labor. No, I think the objective here is to no, because what they are saying here is just
So they are saying that we should move to.
So we should leave it there. No. Why should we delete it? Why should we delete it, Chair? Why should we delete it? What is your reason? Why do you want us to delete without hard labor?
Go and do hard labor with the prison.
Huh?
You want the imprisonment to go with hard labor?
No, they are saying that without hard labor. They don't want that. The bill
Without
is
hard
saying
labor.
you cannot imprison with hard labor. That's what it means. No, but yeah, so now you want them to delete this so that they can imprison them with hard labor.
That is what it means.
No.
Now, okay, let's delete and read it.
No, you read it. Read it. You read it.
Omit the hard labor.
Now, Chair, what I want him to do is to read it as it is for you to understand, and also to read it as you want him to amend it.
No, now let us just read by deleting it and see.
Huh?
Let's read by deleting it. Like if it is deleted, already we know this is how it is in the bill.
No, you don't know that.
Or read as it is.
And then read so that you know. Because if you see your argument is taken care of as it is, but read as it is, then read as without the hard label. Yes, go ahead.
If the penalty is not paid and cannot be recovered by attachment and sale, the person so bound shall be liable by order of the court, which issued the warrant to imprisonment for 6 months.
No, Honorable Chair, read it as it is, and then you read your proposal.
Start. That's the proposal we are saying. The one I read.
No, read as it is first.
Read everything as it is without the change.
Then after you read your proposal.
If the penalty is not paid and cannot be recovered by attachment and sale, the person so bound shall be liable by order of the court, which issued the warrant, to imprisonment without hard labor for 6 months.
Yes. No, now read your proposal.
Agree. Without hard labor.
Yes. That's why I said that. You didn't understand earlier. It is proposed that clause 136, forfeiture of reconnaissance, stands part of the bill as it is. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Clause 137, ordering of fresh security upon original order.
Clause 137, ordering of fresh security upon original order. It is proposed that clause 137, ordering of fresh security upon original order, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 138, power to direct levy of amount due on certain reconnaissances. 138.
Clause 138, power to direct levy of amount due on certain reconnaissances. It is proposed that clause 138, power to direct levy of amount due on certain reconnaissances, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 139, all necessary particulars of offense to be specified.
Clause 139, it is under subpart 10, charges and information. Clause 139, all necessary particulars of offense to be specified. Chair. 139B, the committee.
That may be necessary, yeah. 139B.
139B, the committee recommended that B to be added after May.
As may be necessary.
Look at B, minority. Sub B, such particulars as may be necessary. They want to add B between may and necessary. As may necessary for giving reasonable information, but they want to say as may be necessary. That's correct. It is proposed that clause 139, all necessary particulars of offense to be specified, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 140, joinder of offenders.
Clause 140, joinder of offenders. It is proposed that clause 140, joinder of offenders, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 141, joinder of two or more offenses in one charge or information.
Clause 141, joinder of two or more offenses in one charge or information. Committee, Chair.
No.
It is proposed that clause 141, joinder of two or more offenses in one charge or information, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 142, rules for the framing of charges and information.
Clause 142, rules for the framing of charges and information. Chair. 142.14, where is this? 142, clause 14. On page 78.
Yeah.
Clause 14.
Exactly. The committee recommends to change reasonable clearness to reasonable clarity.
Clearness
14.
To clarity. To make it very clear and to clarify. Clarity.
14, sub 14.
So that is page 78, clause 14. You know, the second to last line, such a manner as to, sub 14, as to indicate with reasonable clearness the place, time, with reasonable clarity, the place, time. I don't know. With reasonable clearness, the place, time, with reasonable clarity.
Chair. These two can substitute each other, so we need to know from the legal team which one is legally suitable. Sherwood thinks this is for real. Let's hear from the legal team.
I take offense that this is the work of a committee, not the work of an individual.
I withdraw.
Honorable nominated member.
I withdraw. I humbly withdraw.
Unconditionally. Nominated member, is that withdrawal humbly or unconditional?
Humbly. But still, I want the legal minds to guide us.
Attorney General, please. Nominated member Kebalang is asking between clearness and clarity, which is more suitable here? Or you are debating? Is the amendment in order or? Clearness, the place. Reasonable, indicate with reasonable clearness the place, time, thing, matter, act, or omission referred to. With reasonable clarity. The place, time, thing, matter, act, or omission referred to. Clarity is more suitable. Or clearness? Yeah, I'm asking, I say whether clarity is more suitable or clearness. Yeah, he's still pondering. Okay, Chair, yeah, you can go ahead, sir.
These two words are kind of synonyms. It's a matter of choice. All of them can be right, but clearness is strange. Clarity is more common and easily understood. That's why. Legality in the use of these two words. It's just communication. You want to communicate clearly, you are heard. No legal issues there.
Clarity. So communicate with clarity, right, Chair? Yes. Yeah. Yes, Ken West.
All right. Honorable Chair, I think their explanation makes sense. So going by the submission, I think definitely to communicate with clarity, I think the explanation makes sense for one to go by.
Attorney General. Attorney General, the young hold belay. Attorney General.
We have no objection to the suggestion.
It is proposed that clause 142 It is proposed that clause 142, rules for the framing of charges and information as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 143, plea agreement negotiation.
Clause 143, plea agreement negotiation. Chair, yes.
143, 1A, the committee recommends that the word include be deleted. And the clause should now be read as lesser offense.
143, the committee recommends that the word included be deleted. 143 sub 1A, the committee recommends that the word included be deleted and the clause should now be read as lesser offense. 143 1A. Reduction of a charge to a it should read now the reduction of a charge to a lesser offense. They want to delete the word included. Nominated member Kebalang Fofana, you have the floor.
Chair, my question here is, if you say the word included, it means like it is part of something or it is more than one. So now, if they say reduction of a charge to a lesser offense, what if this individual is being charged but with more than one offense? And what do we do?
Yes, yeah, because if this is to include
Yes.
the lesser.
Yes. So if it is multiple charges now and you've taken out, deleted the word included, how does it affect that substantive?
Because here is to allow the inclusion of lesser offense into those maybe serious or major charges that he have. I think, yes, Janjambure, you are making some.
Yes, that was going to be my point as well, but it will be important to also find out from the drafters what intent do they have to include that word, because for me, I think it's important.
Yeah. Chair?
The committee's candid opinion is this really does not cause any harm. It's saying that you just delete include and said reduction of a charge to a lesser offense. Here the key things are there. The offense is there. And then this one is qualifying it to be a lesser one. So I don't see any issues here, but maybe the minister and his team we could hear the opinion on it and see.
During the plea negotiation, to reduce the charge to a lesser offense. Maybe if the charge is a major offense, you agree there is a plea bargain, and then now you are now moving from felony to misdemeanor or what? Or from depending on the charge. Yes, Attorney General.
I will agree with the deletion, because usually when we charge, we don't charge both the higher offense and the lesser offense together. Let me give an example. When we charge you for murder, we don't also include manslaughter in the same charge sheet. So if we are negotiating with you and agreeing to a lesser charge, then we will substitute the murder to manslaughter. So if you say to a lesser included offense, myself, I'm struggling to understand what the drafters were intending. Because would they mean that the lesser offense that I should negotiate with the offender must have been included earlier on? And that's normally not our practice. When we charge a higher offense, the lesser offense is not included because you will not make sense.
Maybe also the drafters are foreseen in a circumstance, in a situation where they will charge you for both the major and the lesser offense.
We don't normally do that.
No, I said you don't normally do that now, but maybe in the future, in the event that it occurs.
Usually, though, I mean,
Nanda, it is bad to cater for the likelihood of, or the unlikelihood of including those things. In some jurisdictions, they charge both murder and manslaughter. They want to take care of both so that in the future, if we evolve towards that end, that would have been catered for already.
Irrespective, whether
if they are to charge murder and manslaughter, then what would be the penalty?
Please, member for Serekunda, I always say, don't use the mic without request. Please don't do that. No, please.
Honorable Speaker, the risk here is if you leave it to a lesser offense without limiting it to those included, you have the prosecutor had a better free hand. Because a lesser offense is a lesser offense, whether it's included in the charge sheet or not, he can settle for any lesser offense than restricting it only to a category of lesser offenses. Because this include here, I'm struggling to understand what they intend.
Now, this one, during the negotiation, if in the future, now you don't have that the guy is charged for both major and lesser offenses, and the negotiation to include all of them. Now, what we are saying, even if in a scenario that happens, you can still negotiate without putting the word.
Currently, what we have is, if you are charged for a higher offense and our procedures, if the evidence presented by prosecution cannot secure a conviction for a higher offense, the court is obliged to review the evidence to see whether it has disclosed a lesser offense. And if so, it can convict you.
Okay, now
for the lesser offense.
Now, if so, on the lesser offense now, instead of him convicting you or continue the proceeding, the prosecutor, on the lesser offense, can you still use your plea on the lesser offense? And probably...
Yes, that's exactly what we are saying here. Okay. That's what we are saying here.
It is proposed that clause 143, plea agreement negotiation, stands part of the bill. Those in favor, please say aye.
Amendment.
Or
With amendment.
we are deleting included. It is proposed that clause 143, plea agreement negotiations with amendment, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 144, plea agreement on behalf of the state.
Clause 144, plea agreement on behalf of the state. Chair?
We want to forgo it because it was flagged during the retreat and then open to the opinion of the committee, and nothing has been done about it. So we leave it as it is.
It is proposed that clause 144, plea agreement on behalf of the state, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 145.
Clause 145, initiation of plea agreement.
Clause 145, initiation of plea agreement. It is proposed that clause 145, initiation of plea agreement, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 146, consultation with victim, etc.
Clause 146, consultation with victims, etc. Chair, it is proposed that clause 146, consultation with victims, etc., stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 147, form of plea agreement.
Clause 147, form of plea agreement. Chair?
Yeah. Clause 147D. D. The committee recommends for this subclause to be redrafted and now read as be assigned by the prosecutor accused by the prosecutor, accused person, and his or her legal representative where applicable.
Honorable members, when you look at clause 147D, they are now proposing for a redrafting of that clause, and the clause as it is, it's be signed by the prosecutor and the accused person or his or her legal representative. But the new clause, they want it to read as follows: be signed by the prosecutor, accused person, and his or her legal. The new thing, instead of two signatures, they are now not for three, but the legal person can sign on behalf of the accused person. That's what they're proposing now. No. Now they are proposing, yes, instead of, as it is two, they are proposing three. An accused person and his or her legal representative were applicable. They want to add a third person where applicable. That will be the legal representative. Yes, to sign. Member for Latikunda Sabiji, you have the floor.
Yeah, thank you very much. My only problem with this plea agreement, sometimes it's abused by the state. They will, especially if they are co-accused, they will just plea bargain with the other accused to come and lie seriously against the other accused. So the co-accused, for me, I don't know how do we improve the text so that they can also be protected in case the state entered into a plea bargain with another accused person to protect the other co-accused person. Because it's time without numbers. This has been abused by the state. The co-accused will come and seriously lie against the other co-accused.
Attorney General, it is proposed that clause 148, no? It is proposed that clause 148, recording of plea agreement by a court as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 148, recording of plea agreement by court.
149. Oh, then we have not voted on 47.
We are on 47. That's where D is.
Oh, yeah, we have not voted. All right. It is proposed that clause 147, form of plea agreement, as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. If you have on something on 148, we have already voted. Maybe we can. Do we still have to resend it? We have yeah, but I already we voted on 148.
But without
We-
Clause 148, recording of plea agreement by court.
Clause 148, recording of plea agreement by a court. Chair?
Because we were thinking that B was left out, but going by this, really, B is there, so it's okay.
It is proposed that clause 148, recording of plea agreement by court, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause.
Vote on. Member for Oliundum?
Yes, I actually wanted to put a motion for the consideration of section 143. Section 143, we've already passed it. I just wanted us to do a reconsideration of it. Probably the minister will want to clarify something. We have already voted on it though, but I think I'm only moving that we reconsider section 143 again, if you allow us.
Yes, Honorable Speaker, if this is accepted.
Yes, now the member for all you want us to rescind a decision on 143. Now we want to hear from you if there, please, if there is merit for us to go back and rescind the decision. Yes, please, Olundum or Attorney General.
Yes, Honorable Chair. I wanted to move that we rescind our earlier decision on section 143 and do a reconsideration of the article we deleted. That is the word included, because I think the minister said they needed that article in that particular section, and probably he can do a more clarification on the word for us to hear. Yes.
Yeah, Attorney General, please go ahead.
Yes, we just checked and confirmed that the phrase is an expression in criminal law, lesser included offense. So we were reading it separately, but read together, lesser included offense is an expression in criminal law, meaning an offense that has all the elements of a, in another word, lesser offense itself, but it's expressed as lesser included offense. We appreciate that, so that the included is left there.
Yes, now we will allow him to move the motion for us to rescind the decision, and then we debate on it.
Okay, that was where I was coming, because I think we should be guided by his motion than just... I didn't think I wasn't too attentive. Do you mean you're going to work on the clause and then?
No. We just want you to rescind your decision to delete included.
To maintain it as it is.
So lesser included offense in quote is an expression in criminal law. When we remove the included now, we lose the meaning. We want to restore it back here.
Okay.
Apply, please.
So I actually want to move a motion that we rescind our earlier decision on section 143.
Any second?
Seconded.
By who? Nominated member Kebalang. It is moved and seconded that our earlier decision on clause 143 plea agreement negotiation. This is 142? 143 plea agreement negotiation be rescinded. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Now, yes.
Chair?
We are going to 149 now.
No, I think it's in order. Since you've rescinded our earlier decision, which means the word included is part of what the clause.
Thank you. It is proposed that clause 143 plea agreement negotiations stand part of the bill as it is. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 149, competence of accused person to make a plea agreement.
Clause 149, competence of accused to make a plea agreement. Chair, it is proposed that clause 149, competence of accused to make a plea agreement stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 150, record of factual basis of plea.
Clause 150, record of factual basis of plea. It is proposed that clause 150, record of factual basis of plea stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 151, addressed by parties.
Clause 151, addressed by parties. Chair, now I've been informed that by a technical department at the control room that you are never audible, the member for Busumbala. So they want you to get closer to the mic so that they can hear what you are saying.
That's fine, that's fine. Clause 151B, the committee recommends that this be added before the word act.
151 B. 151, there is no B. No, that should be 2 then.
Fifty-one 2B. 2B.
Clause 151B. Okay, clause 151.
Yes, it's correct.
2B. Okay, in accordance with the act or with this act. They want to add with in accordance with this act. It is proposed that clause 151, addressed by parties as amended, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 152, rejection of plea agreement.
Clause 152, rejection of plea agreement. It is proposed that clause 152, rejection of plea agreement, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 153, withdrawal of plea.
Clause 153, withdrawal of plea. Chair, it is proposed that clause 153, withdrawal of plea, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 154, finality of judgment.
Clause 154, finality of judgment. Chair.
Clause
Please
1.
Throw your mic down so that you can hear.
Clause 154.2. The committee recommends the drafters to draft a new sub-clause 3, which shall encompass the concern of interest parties mentioned in this section. That is our recommendation.
For them to redraft.
Yeah.
Was that communicated to them? Drafters, have you redrafted? Have you drafted a new sub-clause 3, which shall encompass the concerns of interest parties? My
I said this drafting instruction is not clear. We don't know what do you want us to draft, you said, because it's very vague. What you just said is very
interest of parties.
I will repeat what I have always said here. We did this together, and there was an agreement that this particular section should be redrafted to take care of these things, and we agreed. And
so
then,
at this time,
like I said,
at this time, were you able to give them a proposal for them to go and couch it in a legal way?
Oh, but I can only fully remember also, well before this session, I had a telephone conversation with the Honorable Minister to say that this thing was done a long time ago. There are things that we have agreed. Can we form a subcommittee to look into this before the session? And he promised to get in touch with the Solicitor General, and then we can sit over it before these sessions. But maybe due to his busy schedule, it wasn't possible. So we would have gone over these things, and then some of these issues could have been discussed before the sessions.
But can you remember maybe what
I cannot.
What parties interest you? Okay.
I cannot.
Then what do we do next year? What is your suggestion on this one?
The body that finalized everything. Even if you had decided anything, could be changed here. So the decision of the plenary will stand.
Now, can you help us with probably what do you think could be of interest of the parties?
I don't know. I think for me, really, Mr. Chair, if you want to have my opinion on this, we'll just let it go because, like I said, we have had agreement with the ministry. I reminded the minister so that we can go over these things before sessions because having experience from the previous sessions, we had these kind of issues and we couldn't trust it out. So that's why before this other session, about 2 months ago, I told him so that let's have a subcommittee to sit outside and discuss these things, but it didn't work. So now I think we just have to leave it as it is.
Thank you, sir. Member for Kiang West, you have the floor.
Honorable Chair, where I was trying to get to is they should be able to tell us what was missing that they think should be redrafted and included. If we don't know what was missing that they proposed to be included, and then it doesn't make because this will help the drafters to draft what they want there. So if they don't know what was missing and that they think can be included, I think we let it go. Because they cannot tell us what was missing in this clause that they think should be included and redrafted. So I think we need to move on.
It is proposed that clause 154, penalty of judgment, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 155, protection of plea agreement process.
Clause 155, protection of plea agreement process. It is proposed that clause 155, protection of plea agreement process, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 156, rules under this subpart.
Clause 156, rules under this subpart. Chair.
Clause 156. The committee recommends for the word sub in the title and now to be read as this part instead of subpart.
I don't know, we have a lot of subparts in the past and we have a lot of subparts. Even this one I announced, it was a subpart of which it is under. It's a subpart. It's part of the subpart 12. Huh? Subpart 12. Subpart 11. That is plea agreements. You know, it has parts and subparts.
Honorable Chair, we're making reference to 56. Even top there, 56, where it says rules under this shop part, that shop should be deleted. Then come down, say the Attorney General may make rules for the better carrying into effect of these provisions of this shop part also removed.
You know,
that's where. Those are the two we're talking about. Yes, and then that's it. I think those are the two under 56.
You know, Chair, you see, under 56, it's part of the subpart 11 of plea agreements from clause 143. From clause 143 to clause 156 is part of subpart 11 pre-agreements. So it includes those clauses as well. It's referring to those clauses. You are fine now? Okay. Clause 156. Okay. It is proposed that clause 156 rules under this subpart. No. Huh? Is that where we are? Yeah. Okay. It is proposed that clause 156 rules under this subpart stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 157, persons convicted or accused not to be tried again for same offense.
Clause 157, persons convicted or acquitted not to be tried
Chair.
again for same offenses. It is
Chair.
under subpart 12, previous conviction or acquittal. Yeah.
Yes.
Nominated member Kebalang Fofana.
Thank you, Chair. Chair, if you look at clause 157, it is subject to section 322. If you look at section 322, it provides for the basis under which the Attorney General can make appeals against the acquittals of what? Persons. If you look at 2 and 3, where people can be charged on offenses where they have been acquitted.
That is 158 sub 2.
No, we are at 157.
Okay, yes. I mean 157 sub 2.
Yes, maybe I'll cut it short. I'm okay with 1, 2, and 3. The only bone of contention I have is with 4. And with 4, it is saying that notwithstanding such convictions, no, I will read it in full. A person convicted or acquitted of an offense constituted by any act may, notwithstanding such convictions or acquittal, my problem is with the acquittal, be subsequently charged with and tried for any other offense constituted by the same act which he or she may have committed if the court by which he or she was first tried was not competent to try the offenses with which he or she is subsequently charged. So, what do we mean by saying if the court by which he or she was first tried was not competent?
Attorney General. Attorney General, that's this thing. In fact, I think what the what nominated member Kebalang Fofana, honorable members, what the honorable nominated member Kebalang Fofana is doing our attention to, it looks like you can be charged, tried, acquitted, or convicted later on again the same.
So I just want clarity from
Attorney
him.
General,
With 1 and 2, 1, 2, and 3, I'm comfortable. But 4, if we can have clarity on that.
I think nominated member Kebalang Fofana, what they could do is to appeal judgment if they are dissatisfied with judgment, but they cannot after some time to say you were convicted of that, we are bringing the same charges again. That's persecution.
Usually, if you are charged before a competent court, you are acquitted or either convicted, and from the same facts that led to that trial, you cannot be charged again, even if the facts disclose a different offense. The state is deemed to have missed its chance because you should have charged everything at once. You have an opportunity to charge the person at once. What this clause is saying, that rule will not be applicable if that trial took place before a court that at the beginning was not competent to hear the trial. If it is a competent court that could have had all the charges and you choose to charge him for something, so which means you picked what to charge. Whether you succeeded in conviction or an acquittal, you cannot turn around from the same set of facts to charge again.
Attorney General,
yes.
What is competent court?
The competent court here has to do with jurisdiction. You know, the jurisdiction of the court determines its competence. And in criminal law, certain courts have jurisdiction to prosecute, to try certain cases, and some courts have jurisdiction to try different cases. So if you go to the wrong forum, the court doesn't have a jurisdiction.
Yeah.
For
now,
that issue.
Now, would that be the fault of the accused person or the prosecuting agents? You prosecute someone and he's convicted for whatever reason, you want to come back again and then try him the same offenses. That's persecution or malice.
No. Well, we can hear more coming, but this is slightly different, Honorable Chairman, from the other atrophia acquit and atrophia convict principle.
I think this one we should look at it. I'm in line with I think what the nominated member Kebalang Fofana is bringing. Yes. Yes. Four. Look, read 4. Yeah, nominated member Kebalang Fofana, please.
Yes, because Chair, you read my mind because I was going to ask whose responsibility would it be to ensure that the trial is conducted in a competent court, and that would be the responsibility of the prosecution.
So, nominated member, are you proposing for us to delete 4?
I mean, in the absence of any other substantive explanation, I think I would not be convinced to leave sub 4 here.
Read 4,
Yes.
Majority Leader.
Yes. Because the responsibility to ensure that the trial is done in a competent court lies with the prosecution. So,
And then you always have cause to resort to. You can challenge the competence if the court is going in a court. You can challenge the competence of the court into a higher court. But you cannot just put this thing like that. You prosecute somebody, convict him on that, and again you want to go to another court. Come on. Come on. Yes, Dad.
I think that is why you have what they call competent court. We are human beings. The prosecutors can be wrong, but that doesn't mean that it should not be corrected.
That's why they can record something to redress. They can go to another court to challenge the competence of that court. Then whatever the court decides, that's it. But you cannot put this thing here like that. You are convicted on something. Later on, we just grab you, take you again to another court for the same offense. That is not correct. Honorable members. Janjamure, please.
Yeah, I was suggesting we just delete clause 4.
Subclause 4. So with that amendment, right, it is proposed that clause 157, person convicted or acquitted not to be tried again for same offense, stands part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause.
Deleting clause 4.
Subclause.
Deleted. Sub 4. Yes. Yes. Clerk.
Clause 158, previous conviction, how proved?
Clause 158, previous conviction, how proved? Chair? It is proposed that clause 158, previous conviction, how proved, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 159, leave of Attorney General necessary before prosecution instituted.
Clause 159, leave of Attorney General necessary before prosecution instituted. It is under subpart 13, offenses by foreigners within Gambian waters. Foreigners or non-Gambian? I But foreigners also
159.
Foreigners also means non-Gambian. 159. Chair, do you have? Attorney, Majority Leader, they have something on the, yeah.
Yes, 159, 2A, B, and C. The committee recommends that wherever consent and certificate appears on the clause of mentioned section, certificate should be maintained instead of consent. That's our...
No, Attorney General. No, it's the same thing. I think consent is. I don't know. Anyway, yeah, the Attorney General must. Exactly. Exactly. Sorry, Attorney General, your mic.
The certificate is the evidence of AG's consent. So if you are removing consent, what is he certifying?
Exactly.
Then the prosecution might as well proceed without seeking AG's consent.
Exactly.
And I don't think that will be suitable for this. There are certain offenses in the criminal code. There is a reason why they are subject to AG's consent.
Exactly.
So that no other prosecutor can proceed without Attorney General's office looking at it properly.
He's right.
It's not.
So, yes, I think the AG is right. So, Chair, we are okay. We are okay as it is. Clause, it is, Kenwes here. It is proposed that clause 159, leave of Attorney General necessary before prosecutions instituted, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 160, summons for witness.
AG, you want something? AG, you want to say something? Hmm?
60.
Oh, you're fine. Okay. Clause 160, summons for witnesses under subpart 14, compelling attendance of witnesses. Chair, it is proposed that clause 160, summons for witness, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 161, warrant for witness who disobeys summons.
Clause 161, warrant for witness who disobeys summons. It is proposed that clause 161, warrant for witness who disobeys summons, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 162, warrant for witness in first instance.
Clause 162, warrant for witness in first instance. Chair, it is proposed that clause 162, warrant for witness in first instance, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Class.
Okay. Clause 163, mode of dealing with witness arrested under warrant.
Clause 163, mode of dealing with witness arrested under warrant. Chair. It is proposed that clause 163, mode of dealing with witness arrested under warrant, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 164, power of court to order prisoner to be brought up for examination.
Clause 164, power of court to order prisoner to be brought up for examination. It is proposed that clause 164, power of court to order prisoner to be brought up for examination, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 165, penalty for non-attendance of witness.
Clause 165, penalty for non-attendance of witness. It is proposed that clause 165, penalty for non-attendance of witness, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 166, power to call and recall witnesses.
Clause 166, power to call and recall witnesses under subpart 15, examination of witnesses. It is proposed that clause 166, power to call and recall witnesses, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 167, evidence to be given on oath.
Clause 167, evidence to be given on oath. It is proposed that clause 167, evidence to be given on oath, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 168, refractory witnesses.
Clause 168, refractory witnesses. It is proposed that clause 168, refractory witnesses, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 169, analyst report to be evidence in all courts.
Clause 169, analyst report to be evidence in all courts. Sure. No issues. It is proposed that clause 169, analyst report to be evidence in all courts, stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 170, issue of commission by the High Court or a subordinate court of first or second class for examination of witness.
Clause 170, under subpart 16, commission for the examination of absent witnesses. Clause 170, issue of commission by the High Court or a subordinate court of first or second class for examination of witnesses. I've been drawn, my attention have been drawn to the fact that we lack quorum. After starting is 20. 99. When we but we are not on break. Well, what yeah, because we lack quorum, I have to go up there so that to instruct that we ring the bell for 5 minutes. The House resumes. At this point, we either go on break or I instruct that they ring the bell for 2 minutes.
Let's break for lunch and prayers. Convenient time for break, lunch and prayers.
Okay, we break for leaders for how many minutes? 1 hour or?
3 o'clock. We come back 3.
For leaders. This one is for all of us.
Now that we lack quorum, and then it's a convenient time for us to break for prayer and lunch. For an hour, the House will resume by 3 p.m. The House is suspended.